All right, Jeff, before you shut up, just confirm for me, please, that I've got the right screen up because I know I always screw that up.
No, you don't, but yes, you have it. You have the proper screen on here.
Okay, that's all we need to know. Thank you, sir. All
Oh, wait,
right,
is that
so
social security number supposed to be there? No, I'm just kidding. Go ahead. Go ahead. We're all
there's no
set.
money in the accounts. Don't worry about it. Everyone, welcome to our covenant enforceability for HOAs and condos class. As Jeff mentioned, my name's Alan Schwartzide. I'm the managing attorney for K. Bender Rembaum's Orlando office. Our main office is in Palm Beach, Florida. We also have offices in Pompano Beach, Florida. We also have offices in Palm Beach Gardens and in Tampa, and also by appointment in Miami. We've got 20 attorneys that are doing all of this community association law and pretty much nothing else except our one attorney who is board certified in construction. So anything your community association might need, feel welcome to reach out to me directly, reach out to the firm, because that's literally all we do. We'll be pleased to help you if we can. We're also pleased to present this seminar for educational purposes. If your community ever needs legal representation, please think of us. Please do not treat anything that is said today as legal advice. That's not how it's intended. It is just a general educational program today. So moving along to the actual presentation. So why do we have the right to enforce? What do we need to do here? When we talk about covenant enforcement, let's first start with what the heck are we talking about? When we talk about covenants, what that means is there are items in your governing documents, generally going to be in your declaration of covenants, your CC&Rs, whatever you want to refer to them as. Not generally going to be in your bylaws, by the way. It is going to be generally your covenants, conditions, restrictions, easements, your declaration. So what that declaration is normally going to say is it runs with the entire community. What that means is everyone that buys into the community is obligated to comply with that, whether they expressly, meaning in writing, or they said, hey, yeah, I'll go ahead and I'll do what the declaration says, or not. Doesn't matter. It's recorded in the county public records. Everyone's on what's called constructive notice of everything that is in that declaration, including your covenants. Your covenants are generally going to be your use restrictions. What are you allowed to do and not allowed to do, either on a lot or in the community as a whole? That's what we're talking about today, is enforcing those covenants when someone violates them. So the first thing that we talk about when we talk about these covenants, the right to enforce these things must generally be in the declaration or in rules that the board has created that are supported by the declaration. Otherwise, you can't enforce, because what are you enforcing? You don't have a document that says you can't add to your lot, you can't add an improvement without the board's approval, without the architectural committee's approval, etc. If that condition is not in your governing documents, it's not something the association can enforce. So the first thing we want to look at is, what do the governing documents actually say people are allowed and not allowed to do? Are there rules and regulations? Do they actually go forward with what's already in the declaration, or are they just making things up now that is not necessarily supported by the declaration? The most important thing I will tell you today, there are two of them actually. The first is that second bullet point right here. The directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the association. I will tell you, it's almost never going to be in the best interest of the association to ignore all of your covenant violations and just choose, you know what, people own their lots, people own their units, they can do whatever they want. That's a bad idea, because what it's going to lead to is people doing exactly that, whatever they want. And it leads to deteriorating property values very, very quickly. So what you want to do is, and this is item number 2 that is crucial for an association, you want timely, consistent, and uniform enforcement of your covenants. What this does is it maintains the board's credibility. It shows that the board is actually going to follow through on what you say you're going to do. It avoids most of the major affirmative defenses to covenant enforcement. And I literally wrote the book on the subject for condos and HOAs, so I might know a little bit about this. But most of the major defenses, if not all of them, to covenant enforcement are avoided by being timely, meaning you move forward with your enforcement mechanism within a reasonable time after you discover a violation. It's consistent, meaning that you treat everything the same. You don't enforce one and not enforce the other violation. And you treat it uniformly among all your members so that you don't have selective enforcement. If you do all those three things, timely, consistent, uniform enforcement, You're almost never going to have someone succeed with a defense. Okay. There are things that we'll talk about later that if you haven't been doing it that way, you can make some changes in the way that you do it and let everyone in the community know through what's called rehabilitation, republication. You let everyone in the community know, listen, there's a new sheriff in town, even if there's no new sheriff. We're going to be taking our enforcement mechanism seriously going forward. I'm going to apologize if my tongue ties up a little bit. I'm a little under the weather. So you're still getting my best, but I might have to pause and step back once in a while. The other thing you want to look at is vague language or invalid amendments in your community documents that you might want to clean up so that everyone knows what they're actually obligated to do. Okay, this is not really a defense. That's one of the things that people can claim. I didn't know what my obligations were. It's really a denial, but it still could enforce your, it could avoid your enforcement efforts if this is something that's in the governing documents. It's just not clear what you need to do. Now, we talked about this fiduciary duty. In line with that fiduciary duty, my strong recommendation to every community association director and officer is to ensure you've got directors and officers liability insurance, because you don't want someone coming after you personally for failing to take action, which they can do. You're given, some discretion to make your best business judgment as to what is in the best interest of the community, but you want to make sure that your decisions are being made not on an emotional basis, not on a, well, let's help them out basis, but on a, we are running a business and we have a responsibility to the community as a whole that is the same as being a trustee of that community. So make sure that you're doing everything the right way. Now, specific covenants and restrictions that the board's responsible for enforcing. Some of these might exist in your governing documents. They might not. Okay. You might have architectural standards and what happens when someone wants to alter their parcel, make improvements to the parcel or a unit. You might have age restrictions, which are very limited. I would look into some courses specifically relating to 55 and older communities or similar communities, if that's something that interests you. Pet restrictions, which again, our fair housing class goes into this a lot more detailed as to what you can and can't restrict regarding emotional support animals and service animals. But generally speaking, pet restrictions need to be pretty clear. If a cat and a dog are not a fish, so if you're only saying you can't have one type of animal, make sure you're pretty specific as to what you want to really preclude. Now, at the same time, if you're sitting there and being extremely vague, saying only pets are allowed, well, I know people that have pet emus. So is this, is a donkey that happens to be a pet permitted because you're only allowed to have animals that are customarily pets? I don't know. That's something a judge will have to decide. So what you want to do is make sure that your governing documents are clear enough to say what you're actually restricting, and then you follow those documents. You might also have restrictions on leasing and sales. I don't remember if we just did that class or if it's coming up next week, but that's another one to look into. I've done it several times. We have all of our past classes are recorded and available on our website at kbrlegal.com under the resources tab. Similarly, guest and occupancy restrictions. Does someone automatically become a tenant if they're there for 14, 20 days? What do your governing documents say? You're going to want to know what those restrictions are so that you can properly enforce them. You're also going to want to make sure they're clear so that you know what you're enforcing and what you're not, and what you can and can't enforce. You might also have parking and vehicle restrictions. And then one of the toughest things to prove is nuisance conduct, because that's basically, listen, let's be realistic. This is what it means. Someone in your community is pissing off everyone else. That's really what a nuisance is. It's someone who is making a problem for the quiet enjoyment of other units. Now, you may have a different definition in your governing documents as to what nuisance specifically means for your community, and that's what a judge is going to look at if you're trying to enforce that provision. So you're going to want your attorney to take a look and make sure that if you're treating something as a nuisance because it annoys someone on the board or the entire membership, just make sure that the provision in your documents actually labels that as a nuisance. If it's sound, but your governing documents only talk about damage to the property as a nuisance, sorry, but that an obnoxious 2 a.m. bumping base is not going to impact whether or not there's a violation of this nuisance provision, and you're going to have to try and find another way to go after these covenant violations. Or they might not even be covenant violations if your covenants don't say that someone can't do this. So you want these to be broad enough to encompass every circumstance you want to prohibit, but also specific enough that it's clear that what someone is actually doing is a violation of these covenants. That's the bottom line that this slide is intended to express. Now, you shouldn't expect someone to stop a prohibited activity unless you actually tell them to stop. So when we say covenant enforcement, that doesn't just mean we don't want them to do it anymore. It means you actually take another step and send the owner a notice of the violation. Now, I know we have mail here. If you've got email addresses, fantastic. Send it via email too. Give it every opportunity for these people to actually get the notice. I literally just got a trial result this morning. And one of the arguments that the other side was making, the owners of this property, was we never got any of the notices that were sent out. Well, if you send it to an email address, I find it even less likely that that's not going to be received by the person that's trying to get it.
Hey, Alan, I have a question.
Sure.
When folks in an association agree to receive official business via email, whose responsibility is it to make sure that these emails don't end up in spam or junk folders? Can the association get in trouble for that, or is that up to the individual?
Good question. And that statute was actually changed this year. For HOAs, I think it was the way that we would want it to be as we represent community associations last year for condos. But it basically, both of those statutes now say if you provide an email address for purposes of notices that are being sent by the association and the association sends it that way, it's your responsibility as the owner and the recipient of those notices to not block it as spam, to make sure that you actually maintain that email address. And if you don't, you send the association the new email address. So the association doesn't get in trouble for sending it out, but the owner claims they never got it. That's on the owner. Good question, Jeff.
And a little general tip is to take your association email address where the emails come from, place it into your contacts folder and your favorites. And it's not 100% foolproof, but it's less likely to end up in spam if you do that.
Excellent point. Thanks,
Right.
Jeff.
Back to you.
So the notice that you're sending, it should include a statement of this is a violation and provide a deadline for compliance. It should also say what the violation is. And this is where I see a lot of management companies and a lot of individuals that don't have a manager making the mistake of saying, you're in violation of Article 12, Section 3 of the Declaration. Okay, thanks. Let me go ahead and pull up the copy of the declaration that, of course, I keep handy on my cell phone. No one knows what that means. Even your attorney has to look it up. And the bottom line is, most of the time when you refer to that provision, they're going to be looking at a provision that has 5 or 6 different things they could be accused of doing. So if it's a vehicle restriction, it could be the size of the vehicle, it could be signage on the vehicle, it could be where it's parked. So you want to be specific and clarify, hey, here's what you're accused of doing. Here's what you have to do to fix it. If you want to throw in that provision of the governing documents, fantastic. That'll help too. But the bottom line is, what you really need to be doing in these notices when you're notifying someone of a violation is to say, hey, you're not doing something that you're supposed to be doing, or you're doing something that you shouldn't be doing. You need to stop. Here's the deadline when you need to stop, or the next step will be taken. Now, if your association's working with us, hopefully you've listened to me and my colleagues at K. Bender Rembaum, and you've established a written policy governing how you're going to enforce your covenants. And it's going to say the association will send 1, 2, or 3 notices, either through management or through the board, that say, hey, we're going to be a little more aggressive in each one of these notices. And then the policy is going to dictate that automatically, without the board having to even vote on it, if that violation is still in place after that 3rd notice expires, it comes over to our firm. We send our, I'll call it a nasty ram, and then we take the next step. If they don't cure it within the 15 days we provide, we'll go ahead and send either an offer for mediation or an arbitration demand, which we'll discuss in a minute. And if they don't comply at that point, we go forward to court and seek an injunction to force them to fix it. Now, there are other options that we'll get into in a minute. But bottom line, you need to make sure that you actually notify the person, here's what you need to do. Here's what we're going to do. Pardon me, if you don't do what we're telling you need to do. And here's when we're going to do it. And if voluntary compliance is not achieved, meaning if the owner doesn't comply within the time that you're providing, the conduct may become subject to mediation or formal action in court, meaning you move forward with the next step in that enforcement policy. I have actually several clients who have hired us just to prepare that type of policy. And I'm not suggesting that that's the best move, but it is something I'm willing to do. If the community just wants a really good policy of how you're going from start to finish within this procedure, it's something we can address. And I recommend that every community have that policy in place. Moving on to authority for fines. Now, I will tell you, I don't like fines. And it's not that I don't like the concept. I think it's great that instead of having to go through all this rigmarole and send out 3 letters and send it to counsel and spend attorney's fees and hope to recover them and hope to get compliance, you're actually able to say, nope, you owe us some money now. The problem is many communities don't follow the required procedure, and others follow that required procedure to levy the fines, which is basically the board meets, you send a notice saying, hey, we're going to have a meeting in 14 days of a separate committee that is not comprised of directors, officers, managers, or any of their family members. That committee then says, yes, we want to pass the fines. If that committee says no, there's no fine. Okay. A lot of people can comply with that. Some don't. What no one does in my experience, and I say no one, and I almost mean no one. I've literally had 2 communities in my career of 15 years in this industry who have actually pursued a lawsuit to enforce fines. No one does it. No one takes it that next step. And what you're telling people if you levy these fines and then don't go after them is, well, we're going to tell you owe us this money, and it's going to be up to $100 per violation, up to $1,000 for a continuing violation, unless the governing documents say otherwise. We're just going to go ahead and leave this outstanding for the next 5 years until the statute of limitations says that it's no longer an obligation you have to pay. Why? What's the point? Why go through that exercise? Just enforce the violation through the normal process, in my opinion. And if you're able to collect it as assessments, which is generally only going to be in an HOA and only if it's $1,000 or more of fines, now you're trying to kick someone out of their house because what? They didn't paint their mailbox when you told them to? I just think that's, listen, I'm not saying I won't pursue it if the board is actually willing to, but there's been literally one instance or one community in my experience that's actually been willing to do that I've represented. And I did collection work for 11 years before I won't say I stopped, but I shifted into other things. So the bottom line is, this is all I did for 8 years, 9 years, and I had one community willing to actually take it to that level. Why just kill your credibility? I just don't see the point. There is case law that suggests that you might not have the ability to levy fines unless it's in your governing documents. I don't agree with the case law. It's from 1999. I haven't really seen it frequently cited. Oops, sorry about that. But just be aware that there is an argument that can be made that fines are only something you can do if your documents say so. Because that is there's a constitutional argument that I won't waste your time with today, but that's where that argument comes from. If you weren't on notice that it could be an issue and the statute changes, the statute generally won't override your declaration with respect to substantive issues versus procedural issues. And again, that's a 20-minute conversation, or it could be an all-day CLE for lawyers that I just won't get into right now. We talked about HOAs, fine of $1,000 or more, may become a lien. It's generally not something that people frequently do. I talked about the fining committee process, so I won't go through that again. So the other argument is that fining is penal and remedial in nature and supersedes a declaration's provisions to the contrary. So the case law goes either way. I think that you can probably fine regardless of what's in your declaration, but I think that unless you're going to take it as far as it needs to go, you're wasting your time. Authority to fine for condos. The association has the authority under statute. The authority doesn't have to be in the governing documents. In a condo, same fining process and dollar limitations apply, but a fine cannot become a lien against a unit, meaning you have even less right to pursue those fines if you're in a condo. We move into suspension of use and voting rights by the board. You can suspend the right of an owner, their occupants and tenants, basically anyone that's at that property, to use portions of the common areas, common elements, common facilities, whatever association property that might otherwise be used. Now, I say whatever other association property, there are limitations. So you can tell them they can't use the pool, the gym, the clubhouse, the rec room, similar recreational amenity facilities. You can also suspend voting rights if the owner is more than 90 days delinquent in any monetary obligation to the association. But suspensions must be approved by the board at a duly noticed board meeting for any of these suspensions. It doesn't apply, and this is where I said there are exceptions. That suspension won't apply, meaning you can't tell someone you can't access the common areas used to provide access to the parcel, utility services, and it can't impair vehicular and pedestrian ingress to and egress from the parcel, meaning you can block them from one method, in my opinion, of accessing the community. In other words, you can shut their gate transponder off and make them go through and show ID at the gate, but you can't tell them you're not allowed into the community until you pay your dues or you cure that violation. In a condo, the suspension can't include limited common elements intended to be used only by the unit. For example, you can't tell someone you can't use your balcony if that's a limited common element. Parking spaces, common elements needed to access the unit, like the elevators or the clubhouse, the entryway to the community. If there's an elevator that they need to get through to access, they need to get through that common area to access the elevator. Can't block utilities, parking spaces, or elevators themselves. As of 2017, the condo, it needs to be $1,000 or more that's owed to the association, and you need to give 30 days notice before you spend any of these voting or use rights. It's just voting rights. This actually works pretty well in my experience, especially in rented parcels, rented units where the tenant has to go through the gate. They will complain to their landlord saying, hey, you need to get me access. I'm tired of having to show my ID because you are not paying your dues or whatever it may be, your assessments. Another avenue that's not mentioned here is send a rent demand to the tenant. It's a statutory letter that gets sent out to the tenant that says, hey, your landlord is past due. I won't give you the amount because that would violate certain fair debt laws, but they're past due in assessments and you have to pay us and it won't say past due. It'll just say there's a monetary obligation that's owed. It'll say you need to pay the association your rent until that past due amount has been paid. Okay. It basically, the statute specifies, and the form letter doesn't specify, but I copy and paste it into the form letter anyway, that the landlord cannot evict the tenant for non-payment if the reason they didn't pay is because they got this letter from the association and they were paying you instead to resolve the landlord's debt, the owner's debt. To take effect, if you're suspending, written notice of the suspension must be mailed or hand delivered. Don't do hand delivery, by the way. I don't think that's a good idea. You're basically telling someone, hey, you can't use the pool. Have a nice day. No, you don't want to do that. Don't take that risk. So mail it. No big deal. It goes to the parcel owner and, if applicable, anyone else that's being suspended from using it. If the voting rights are suspended, keep in mind voting interests allocated to that parcel or unit don't count towards anything for purposes of any member vote, including the number necessary to establish a quorum. So you might be hurting yourself without realizing it by suspending those voting rights, because you might have needed that voting interest, just to have a quorum and actually hold an election, hold an approved action such as an amendment to the governing documents. That vote simply disappears. There is somewhat recent case law that says for declarations recorded before the effective date of the amendment authorizing suspensions, which is 2010, the authority to suspend voting rights needs to be in the declaration, or the declaration needs to incorporate the statutes as amended from time to time in order to be able to suspend voting rights. I don't think that applies to suspending use rights, but there's an argument that it could apply to both. In other words, if your declaration doesn't allow you to do this, you might not be allowed to. You can either amend to include that, or you can make the argument that, listen, it's the owner's obligation to raise this case law. It's not the association's obligation. You are taking some risk if you choose to do it that way, but I don't think it's a major risk. Moving along, you might have a covenant enforcement committee. This is the suspensions for violations of your covenants instead of for monetary payments. It's the same process as fining. It's the same process as all this other stuff. You got your 14-day notice. You've got a hearing before an impartial committee. And so it's basically, and I'll reiterate this just for those that don't remember what I said a couple minutes ago. First, the board votes to say we want to suspend these use rights for this owner's violation of the covenants. The next step, and this applies to voting rights as well. The next step is you send a notice that says within 14 days or shortly after that 14-day period, we're going to actually have a meeting of this separate committee that's not comprised of directors, meaning your board, officers or managers or their family members. It's other people that you might not even be able to get enough people involved to be able to do this, but you can try. That meeting occurs, and then you send your notice saying, hey, your rights have been suspended. It's not until that notice goes out after all of those previous meetings, those two previous meetings, and this notice go out, that those voting rights are suspended. Okay, we've got a bunch of disputes in an HOA that are subject to pre-suit mediation. Mediation is basically, there's no decision maker in the room except for the parties, meaning the board gets to decide what the association's willing to do. The owner gets to decide what the owner's willing to do. There's no judge telling you this is who wins, this is who loses. You either reach a settlement or you don't. That's what mediation entails. So these are the lists, and frankly, the biggest one that we deal with here is covenant enforcement. You violated your covenants. We're going to move forward to mediation because we've already sent those 3 notices through the association. We've already sent the nastygram through Alan's office. And now we have no further remedy except for what we'll discuss in a minute, which is self-help, to get this violation cured. So we send out all the notices. We did everything we could. This is a last-ditch, statutorily required pre-suit notice that we're going to send out. When I say statutorily required, what I mean is a judge can't grant an injunction for an HOA to force someone to comply with the covenants if you haven't sent a statutorily compliant letter that offers to participate in pre-suit mediation. In an HOA, in a condo, we'll get into in a minute, it's an option. It's one of several options that you need to do before you file that lawsuit. So either way, you need to do something before you file. Now, I mentioned self-help a minute ago. One of the things that I suggest and recommend, including in your enforcement policy, is that if this offer for pre-suit mediation is going out and your declaration gives the association the right to enter onto a lot, enter into a unit, and cure a violation and charge the cost of that curative action to the owner that was responsible for the violation, you have to do it. There's case law that came out in April 2022. It's called Moriello. That's the name of the case. And it basically says if you've got a self-help right in your declaration, you can't get an injunction unless you first attempt self-help. There is a much newer case that came out about a month ago. I don't recall the name offhand, but it essentially says if you've got that self-help right, same as Moriello, you've got to try it first. What it added, and which I don't like, but it's what we're stuck with until another case says otherwise, is essentially that you've got to pursue that even for things that make no sense to go onto someone's property and do. So if you've got a general self-help right, that means you can go onto someone's property and power wash their siding. You can go onto their property and remove a building that you don't want on there because they never got architectural approval to install it. Okay. You have to at least make that effort before you can file your lawsuit seeking an injunction. Now, my concern there is, hopefully it's obvious, it's a little dangerous to go onto someone's property and take a building off of their property. If they added a shed and you're just going on there and saying, nope, can't have it, we're taking it off, we told you. Obviously, there is a risk that that owner gets extremely angry and starts to act out, okay? Unfortunately, this case law basically says you have to send the demand beforehand. If you see that they are blocking the association's enforcement mechanism, in my opinion, even with this case law in place, that is sufficient to say, hey, we made our effort, we're going to move forward. Now, back to the reason that I send this at the same time. Most declarations either don't give a time frame or they give like 30 days within which the owner is obligated, or the owner's obligated to cure the violation, or the association gets to move forward with its enforcement mechanism. Okay. Your offer for pre-suit mediation is a 20-day letter according to Florida law. So what you're saying is we're either going to go to mediation and resolve this, or right after that mediation, or right after you ignore our letter, we're going to just go ahead and cure the violation. So you can choose between going to mediation and trying to settle this and giving us a time frame when you're going to cure it voluntarily, or we'll just go ahead and do it for you. Now, going back to self-help, keep in mind, if that's not in your governing documents, you don't have the right to do it. So make sure before you attempt that your attorney takes a look at your declaration to see if the association has self-help. There are some communities where that right is limited to landscaping, things like that. And frankly, with this most recent, case law coming out saying you have to try it if you've got the right to try it, I'm advising a lot of communities to actually limit, in other words, amend their declarations to say they have limited self-help rights so that they don't have the obligation to go and repaint someone's house and risk that the vendor that is doing the repainting is going to be threatened by the owner saying, what the hell are you doing on a ladder on my roof? You're fixing my roof because there's a problem and you're performing self-help. I don't want you on my roof. Get off, or I'm going to pull this ladder off and blah, blah, blah. Okay. If you do not intend to use that right, amend it out and no longer have the right so that you no longer have the risk associated with having that right. Okay. And the risk, by the way, if you lose this covenant enforcement lawsuit, the owner could be entitled to recover all of their attorney's fees and costs. They might be entitled to have nothing paid to the association for its attorney's fees and costs incurred in trying to pursue this enforcement mechanism. And they might be allowed to keep the violation on their property permanently because you lost. So you want to make sure that you do everything you can to protect your community. That policy, the uniform, timely, consistent enforcement, those are all things that I recommend to protect your community. Now, moving along, there are some disputes that are not subject to pre-suit mediation. Again, you'll have these materials later, but we're getting a little late in the hour that we've got available. So I want to give you some time for question and answer. I'm going to skip over some of this stuff. Now, condominium dispute resolution could be the same, could be a little different, because in a condo, you've got a couple options. Instead of in an HOA, you must offer pre-suit mediation before you file your enforcement lawsuit. In a condo, you've got options. You can do the exact same thing. You can send your offer for pre-suit mediation, which is something that we had to fight very hard to get, but just came into the law a couple of years ago, fortunately. That's one option. And frankly, it's the one that I will tell every one of my clients that that's what they should pursue. And here's why. Okay. You can either choose pre-suit mediation, or you can see right here in the first few lines, you can choose binding or non-binding arbitration instead. But you don't choose the arbitrator when you choose arbitration instead of mediation. It goes to an arbitrator that is decided upon by the state of Florida. The DBPR will decide who is going to arbitrate. And their arbitrators, several of them, have explicitly said, we are allowed to be arbitrary in how we decide these arbitrations. In other words, you have no idea what to expect if you walk into that arbitration. You could be 100% correct. Every single judge in Florida would say that you're correct. You should be able to get your enforcement mechanism, and the arbitrator can just decide, no, not today. So that's one issue. The other issue I see in these arbitrations with the DBPR is that they think that really, frankly, in my opinion, absurdly low attorney's fee rates are reasonable based on experience. I've actually seen where an arbitrator stated that $250 an hour for a covenant enforcement matter was a reasonable rate for someone who had been practicing for 25 years. I don't know anyone who's been practicing that long that charges that rate. Now, the other thing they don't do is incorporate reasonable rates within a physical area. So someone that's in Tallahassee is probably charging different rates from someone who is in South Florida or Central Florida. These arbitrators don't take that into account. They just give the lowest rate they can think of, in my experience. So bottom line, I don't think the arbitration is a good idea. I think that mediation is the way to go because it gives you full control over what you're willing to accept and not. If you don't settle at mediation, then you go forward and file your lawsuit, and a judge will make the determination. A judge that is easily appealed, or not easily appealed, but where there is a precedent that the judge is actually required to follow versus an arbitrator who is legally allowed to be arbitrary. So I'll jump off my soapbox real quick. Here's a list of things that are not subject to pre-suit mediation. I won't go through them because you can go ahead and just read that. Like Jeff mentioned, we're going to provide copies of the slides if you need them after the class is done. Additional things not subject to pre-suit mediation. One of the biggest ones that I will point out, and this applies to a condo and an HOA, I know I skipped over it in HOAs, but disputes between and among unit owners and parcel owners, or between an owner and their tenants, are not subject to pre-suit mediation unless the association is actually a party to that dispute. So if you've got John who lives next to Jane, and Jane is complaining or John is complaining about the other one, unless it's something the association has to get involved in or the parties bring the association into it, you let them know we're not taking action on that. This is not an issue that your entire community should pay the attorney's fees to address. You guys resolve it between you two. If you want to file a lawsuit against each other, have at it. Now, the other thing to keep in mind, John and Jane don't have to send each other offers to participate in pre-suit mediation. So because they're not a community association, they don't have that obligation, even if it's property that is within a community association that they're talking about in the dispute. The mediation procedure, we send the offer by certified mail, return receipt requested, copy via regular mail. It basically is a document that is prescribed by the statute. The statute says, here's the form you got to use. You list 5 acceptable mediators and provide 20 days to respond, also via certified mail, saying one of those 5 mediators is acceptable to me to go to mediation. If the owner doesn't agree to mediation, in other words, if you don't get a statutorily compliant response within those 20 days, the owner's not entitled to recover their attorney's fees and costs. This is another reason to send this versus going to arbitration, where it doesn't matter whether they responded or not, they get their fees and costs back if they win. If they respond, fine, we schedule a mediation. You hope to settle it during the mediation conference. And if you can't, then the parties get to decide whether they want to file their lawsuit. If the offer expires with no response or no statutorily compliant response, the association can file that lawsuit immediately, or a petition for arbitration if it's a condo. Now, you know, the bottom line is you're basically sending a letter saying, hey, we told you you needed to fix this. You chose not to do it. This is your last chance before we file our lawsuit. Do you want to get this resolved or not? That's basically what the letter says. It's got a bunch of legalese in it on top of that, but that's basically what this letter is going to say. Now, the mediator will allow the parties to the mediator will start by explaining what mediation is when you're in the mediation conference. And this is something I also do. We've got 3 certified mediators within the firm. I'm one of them, so I know a little bit about it. You know, the mediator starts with their explanation of the process, what their role is during the day. I've already gone through that, so I won't reiterate. And then the parties will each get to present their side of the story. And then you decide, do you want to stick together and try and get this settled, or do you want to break out into separate rooms? Now, the important part of mediation that you don't get with arbitration or a lawsuit, there is complete confidentiality except for in situations of actual abuse or crime. So you can express, listen, I'm really sorry that this is happening. I feel really bad, but we don't have a choice. We have to pursue this because it's not in the association's best interest to let it go. You can say that. They can't bring it up later in court. That's the beauty of mediation. There is mediation confidentiality. Okay, that's something you don't get with any of these other enforcement options. That's another reason I like mediation, because you can be candid about the weaknesses of your case and say, listen, I think you went on this point, but we beat you on these other 5, so we win overall. You can acknowledge that, whereas in court, you're probably not going to acknowledge, well, we're going to lose on this one. You might. Depends on the attorney, and it depends on the position the board decides to take in the litigation. But it's rare that anyone acknowledges they have a weak hand in litigation. It happens, but it's rare. The arbitration procedure, basically you send out a notice of intent to file an arbitration petition. If there's no curative action, the petition's filed. The arbitrator is going to determine first whether the division, that's all, folks, the DBPR has the authority to actually rule on this particular issue. If that's a no, or if the fee wasn't paid, the petition gets dismissed. You got to start over. Have a nice day. If the answers to both of those are yes, then the respondent, the party that didn't file the petition, gets a copy of the petition and gets time to respond. And then you go back and forth, and the arbitrator eventually decides the issue and makes a ruling regarding attorney's fees and costs if that's requested, etc. Keep in mind, even if you go to arbitration, the arbitrator can order you to mediation anyway. So my position is, okay, you might want to just go ahead and move forward. And also, when none of this results in an actual settlement or a final order is entered and the owner doesn't comply, you still need to file your lawsuit. So this is not a final ruling unless it's binding arbitration. Limitations on enforcement, in other words, things that you can't enforce. The Fair Housing Act and Americans with Disabilities Act. I mentioned we've got a class on pets. I would suggest checking that out to get more detail on that issue. The over-the-air something device rule, I can't think of the R, but OTARD is basically where you can't limit whether or not someone puts a satellite dish or an antenna on their property. You can only limit the location, and only to the extent that it doesn't limit the usability of that particular satellite dish or antenna. It's over-the-air devices that this limits. I'll skip over to solar collectors because that's a very similar issue. The association can't say you can't have solar panels, can't have, the case law talks about, what was it? I just read it, Sorrentino case. You can't tell someone they can't have a skylight. That's what it was. Solar collectors. You can't tell them they can't have it, but you can limit the location unless the location limits the effectiveness of what you're talking about. We've got regulations that require associations to allow flags to be displayed. We won't get into detail on that, but you might want to take a look at the statutes governing flags in community associations, because even if you have restrictions that say you can't have X flags or you can't have flags in these locations, you might be obligated to allow it. Florida-friendly landscaping is another one that no one seems to understand, but everyone seems to know you can't go against someone that wants to put Florida-friendly landscaping on their property. And then the most recent change in 2023, one of the more absurd changes that the legislature made in the last year was that anything that can't be seen in an HOA from outside the lot, from the frontage or from the neighboring lots, is not something the association can restrict, regardless of what restrictions you have in your covenants. And the reason that that's absurd is because you've had these covenants in some instances since the 70s or 80s, but all of a sudden they're meaningless. I think that's unconstitutional, and that someone could challenge the validity and enforceability of this new statute. Until someone does, it's technically the law of the land. There are exceptions that I can see. So, for example, is an adjacent lot one that is right behind this lot? Or what if you're across a lake and you can see it, but you're not technically an adjacent lot? The statute is just poorly worded and is a bad idea overall, in my opinion. But until it's changed, which I will be trying to do this year, and I know that a lot of other community association attorneys will be trying to change it. I'm sure that the lobby of attorneys that represent individual owners regularly is going to be thrilled with this. But bottom line, there are things that, regardless of what's in your covenants that we talked about at the beginning of this webinar, you might not be able to enforce them anyway. So just understand, look at all of these issues. If you think there's any chance that they're coming up when someone asks to make a modification on their property, please, for your own sake and your association's sake, reach out to your attorney. If you don't have one, feel free to reach out to me. My email is right here, as@kbrlegal.com. Bottom line, representing community associations is what we do. Covenant enforcement is something I do on a daily basis. And It's one of the more important things that your community can do, largely because if you choose not to do it or you don't do it consistently, uniformly, and in a timely manner, you're basically setting yourself up for failure. And you're going to end up with reduced property values, a community that doesn't look like you want it to, that's not uniform, that doesn't look like it's a community, it's just a conglomeration of homes or units. And bottom line, you just want to make sure that you're doing what you should do and what's in the best interest of the association. And as a director, that is your fiduciary duty, which is the equivalent of the duty of a trustee. So make sure to do what you need to do. Make sure that you're doing it the right way in a timely manner, and make sure that if you're not 100% certain that you're doing it the right way, or that you should be doing it or shouldn't be doing it, that you contact your attorney so that you can get some guidance and know that you're doing it the right way. The other benefit of having guidance from an attorney on literally any issue in a community association is that if you are relying on advice of counsel, it's almost impossible to prove that breach of fiduciary duty. Meaning if someone tries to sue the individual directors, the association might lose, but the individuals should still prevail. All right, so I'm going to start from the beginning. John Zambito has a couple questions here. Does the state statute 720.305 overrule local documents as far as fining procedures? Generally speaking, yes, because that is procedural in nature. So if a statute is procedural, and this is what we talked about, that as amended from time to time language earlier, we call it Kaufman language in the legal industry. But it's basically, if it is a procedural change, if you're changing how you do something and not saying suddenly you have the right or don't have the right to do something, if it's procedural in nature, the statute will govern. So when it comes to fining procedures, you follow the fining procedures set out in the statutes. If your board procedure, your bylaws set forth a more restrictive procedure, meaning that there's more to it, I would follow both. Whichever one is more restrictive and requires more notice, that's the one that I would follow, because you're never going to have someone come back and say, or validly claim that you should have followed the other one because it's less restrictive. No, I gave you more notice. You have no right to complain.
Yeah.
So the board lets the fining committee do the fining instead of imposing the fines themselves and letting the committee vote yay or nay. The board has to vote before the fining committee steps in. Otherwise, there's no basis for the fining committee to step in the first place. So the procedure, I'll go through it very briefly again. Board votes. If that board vote doesn't happen, the fining committee has nothing to consider. Board votes at a board meeting. And now, defining meetings have to be noticed. To the individuals who might be fined, yes. To the membership as a whole, generally, no. The statute dictates what needs to be noticed to the members, what doesn't, blah, blah, blah. Bottom line, no. Fining meetings do not have to be noticed to the membership. But back to that process, board votes. Fining committee gives at least 14 days notice to the individuals who might be fined that there will be a meeting where those individuals who might be fined can come provide evidence to basically say, this is why I shouldn't be fined. If they choose not to appear, or if the fining committee finds that what they're presenting is insufficient, then the association goes ahead and the fining committee levies the fine and notifies the owner or whoever is responsible for the fines that the fines have been levied. Okay. I see a bunch of messages going into the chat. Please, if you have questions.
Oh, Alan, what I'm doing is I don't want to run out of time. So what I'm doing is placing the questions into the chat.
Got it. Okay.
Turn off the Q&A because there's no way we'll get to all of them if we let it keep going.
All right, then I'll go ahead and get started. Marley asks, so you recommend fining system to suspend privileges instead of monetary fining, correct? I recommend that you do whatever you're actually going to follow through on. If it is suspending, fine. If it is fining, fine. If it's both, even better. But don't bother with the fines if you're not going to pursue them in court. Because the first thing you're going to do when an estoppel request comes in and the owner says, well, you know, we could really use your help in dropping down the dollars that need to be paid at closing, that's the first thing that goes. You're going to waive those fines. So if you're going to pursue them, go for it. If it's something that you're never going to pursue, all you're doing is hurting the board's credibility by levying those fines in the first place. Moving forward, Karina Perez, brown drip edge on the roof approved by the last board. Can the new board enforce the bylaws that needs to be white drip edge? Generally speaking, probably not. What you can do is send out, I mentioned earlier, I call it a rehabilitation slash republication letter. Let everyone know that, you know, if you've got these things that are in violation of your covenants, that first of all, no existing violation can be treated as an excuse to violate going forward, so that people don't see this brown drip edge and think that it's okay. And two, it's going to allow the association to say, if this needs to be repaired or repainted at any time in the future, sorry, but you're going to have to replace it with a compliant drip edge. So you can't just go ahead and send a demand notice saying you need to fix this, but there are procedures that you can take that our firm can help with. It's not something that you can do on your own as a community association and just draft these things. I recommend that you have an attorney involved in helping out with this republication process. Karen Beese.
Yeah, can
smoking
smoking be, I'll give you a little bit of a sip your water break there. Can smoking be considered a nuisance?
Logically and legally, yes. Keep in mind, depending on what someone is smoking, it may be something that they have, because I've had numerous instances where people were complaining that people were smoking marijuana on their balcony, which you would think no problem, but the wind blew it right back into the unit below them.
Yeah.
And it got to the point where, because someone had a health condition, you know, they wanted to pursue enforcement against this person who was smoking, but the person smoking also had a medical marijuana card. So you're talking now about potential violations of Americans with Disabilities Act and other things like that. So that's one. If someone is smoking and it's cigarettes, read your governing documents. Like I said earlier, check to see whether odors and things that might impact health concerns, things like that, are listed in your declaration. If not, might be time for an amendment to incorporate that.
Yeah.
Jeff?
Next question is, what is Florida friendly landscaping? And I could actually, is Xeriscape one of them?
I believe so, yes. It's basically landscaping that uses sustainable landscaping practices.
Less water.
It's intended to reduce the consumption of water.
Right.
So Xeriscape is one example. You know, there are a couple specific things that Florida friendly landscaping promotes, but the bottom line is it's promoting the use of less water in your landscaping.
Okay.
Now, keep in mind, people still need to get architectural approval for that Florida friendly landscaping if they're making changes. Right. All of these things that I'm suggesting you can't really regulate, you can still demand the approval. What you can't do is say, no, you can't have it.
This is more of an opinion question. Do you think the fining system will ever be removed from the statutes?
Nope.
Yeah,
I think that the ability to foreclose and lien for fines is in the process of being removed. It's discussed by our condominium committee that is that meets once a quarter. It's all attorneys that practice in this area of law. Mm-hmm. And Allison Hertz of our firm is actually the chair this year, or co-chair. But I don't see that being removed altogether. I do see that at some point, I anticipate that the ability to lien and foreclose for those fines will go away.
Okay. Are board members allowed to attend violation hearings?
Yeah, you can attend. You just can't be on the fining committee.
Okay. Let's see. A violation must definitely be voted on at a duly noted board meeting prior to going to the fining committee, correct?
Correct.
All right. It's kind of like a rapid fire here because we're getting close to the end here.
Yep.
And again, folks, I apologize ahead of time, turned off the Q&A. We just want to be able to get to as many as we could, and there's no way we would have gotten all of them. Do the enforcement guidelines apply to HOAs and condos both?
I don't know what guidelines those are. If you're talking about your internal regulations, yeah. I mean, you got to comply with your internal rules. If we're talking about fining, suspensions, there are separate statutes for HOAs versus condos, but they're not treated very differently. The major distinction of which I'm aware is that in a condo, you need to have, in order to suspend voting rights, you need to have $1,000 in unpaid charges, whereas in an HOA, there's no monetary requirement. You also need to give 30 days notice in advance of that that suspension of voting rights in a condo, whereas you don't necessarily need to give 30 days notice in an HOA. It's just notice of the board meeting when you're going to be considering it.
Okay. If the covenant is in conflict with an amendment, does the covenant supersede?
Depends what's being amended. If an amendment is saying, if an amendment is to the same document where the covenant is found, then it just depends what's in there. Amend out that conflict. If there are two separate documents that we're talking about, so for example, the covenant is in the declaration, but the amendment is to the rules and regulations, it goes in this order. So it's in order of what controls if there's a conflict. It's declaration, which is your CC&Rs, then your bylaws, then your articles of incorporation, then your rules and regulations. I'm sorry, declaration, articles, bylaws, rules, and regulations.
Rex, man. I'm not sure how to interpret this question. See, I'll read it out loud. See if you can. There's two more to go. Two more questions we have here. I know we're about to go over on the time, but just two more. How about a rogue board who makes up the rules, does not get owner vote approval, which is required by declarations according to this person, and fails to enforce on owners, I guess, that they deem are okay, like they're maybe part of the same clique or they're friends or what have you. An example, an owner throws trash out the window and leaves the trash on the lawn. So I don't know what she means by how about, or like, what do you, I guess what can other owners do to combat this, I guess, is the question.
Yeah, I'm seeing that as two different questions. One is, what do you do about a board that's making up rules and is creating rules that require member approval? I'm not aware of many communities in Florida that actually require approval under the declaration of the members to make rules. You need approval to amend the declaration, the bylaws, and the articles in most cases. I've never heard of a community that requires member approval to change the general rules and regulations. If that's the case, then the argument would be that those amendments are not valid because they weren't approved by the members. So technically you might have an obligation, you might not have an obligation to comply with those board made rules if your analysis of the declaration is accurate. When it comes to not enforcing against owners who are okay with these directors, that's selective enforcement. So if they come after you for something that these people got away with, you raise an affirmative defense of selective enforcement, which is basically when they arbitrarily decide to go after one person but not another person for a violation that is similar in the covenant that's being violated, the scope of the violation, the timing of when it was done, etc. Now, overall, it sounds like it might be time for a recall if the board is doing things that everyone doesn't want them to be doing or that are simply not authorized. Or it may just be time for one of the owners to send a demand to this board that they actually comply with the governing documents and point out all these things that they're doing wrong and why it's against Florida law to do what they are doing. Sometimes a letter from an attorney pointing out, hey, this is what you're doing wrong, and my client's going to come after you if you don't stop doing what you're doing wrong, is enough. Or if there's an election coming up, because we're coming into election season, get them out, vote them out.
That question, it's very curious to me, because if they have a management company, you would think the management company would be aware of that and hopefully advising them properly.
Yeah, but keep in mind, I mean, I'm in Central Florida, and it's not quite as common to have a manager, especially in like Lake County,
HOAs.
Some areas where they're just HOAs that have a lot of land and don't want anyone telling them what to do, and I'm okay with that.
Yeah, no, understood. Last question here, and then Alan, we can let you go, and then I'll go over the housekeeping one more time for credits and evaluation. Can a management, speaking of management, can a management company serve as the fining committee for an HOA?
No.
Has been informed that it must be comprised of volunteer members of the community. Thank you.
Yeah, that was a quick no. It can't be any directors, any officers, or any manager. It has to be members of the community who are not any of those individuals. So if the manager is the finding committee and is not also separate, well, even if they are separately a member of the community, the fact that they're the manager means that they can't serve in that capacity. So bottom line, the very quick answer is no.
Okay. Well, that's there were some more questions, but we had to cut it off because of time. But Alan, thank you very much for your very informative session today, as always, and keeping this stuff interesting. You're very, very good at that.
Thank you.
Parting words before I go over the housekeeping one more time, the best way to reach you. And yes, by the way, folks, this video will be on the website within a couple of days for review purposes. And in a moment, after Alan says his parting words, we'll go over the evaluation one more time and how to print your evaluation and how to print the slides. Alan, I see you put your email in the chat.
Yep, that's the easiest way to reach me at any time. Anyone that the other thing I'll point out is that Jeff always sends me a couple days after each one of these classes a list of people who asked to be contacted.
Right.
If you are interested in discussing issues in your community, or you just want to talk about potentially having our firm represent your community, that's something that, all you got to do is literally click a button in that evaluation and I'll reach out, regardless of what that decision might be for each one of the attendees today. I really appreciate you being here. I appreciate hopefully your attention today, and I hope you all got a lot out of it. I appreciate your time, and I hope that you'll continue attending classes with us in the future. We've got a couple really good ones, frankly, brand new ones coming up in the next 2 months that I'm excited to work with Jeff on, and I think we'll have even more going forward in the coming months that we haven't even created yet, but we've kind of discussed. So
yeah.
Stick around.
You're teaching HOA on the 26th. I just put that link to register into the chat.
Yeah, I'll be teaching an HOA board certification course. So if you're in an HOA and you just want an update, or you're new on the board, feel welcome to attend that one, just coming up next Tuesday, just a week from now. So I will stop holding you guys up. Jeff, thank you for your help as always. All the attendees, thank you very much for your time today. Feel welcome to reach out at my email address if you've got any questions whatsoever regarding what we covered today or regarding your community.
All right. Thanks, Alan. Feel free to head out and get some stuff done. I'll stay on for another couple of minutes.